Good afternoon. I'm Tom Leonard, Senior Fellow and President Emeritus at the Technology Policy Institute, and welcome to our panel on the Google search antitrust case, finding a remedy that helps consumers. Last August, in a decision by Judge Amit Mehta, the D.C. District Court found Google liable for violating Section 2 of the Sherman Act. Judge Mehta found that Google had acted illegally to maintain its monopoly in general search and search text advertising. The opinion focused on Google's agreements with Apple, Samsung, and other distribution channels to be the exclusive pre-installed search engine. These agreements helped Google to grow its user base, accumulate data, and improve its product. And this cycle, according to the plaintiffs, deprived entrants of the ability to achieve sufficient scale to compete effectively. So the next phase of the case, which will take place over the coming year, involves finding a remedy, which is often the bigger challenge. We have a great panel to discuss the remedy issues. Ginger Jin is the Neil Moskowitz Professor of Economics at the University of Maryland and served as Director of the Federal Trade Commission's Bureau of Economics. Randy Picker is the James Parker Hall Distinguished Service Professor of Law at the University of Chicago Law School, and Larry White is the Robert Kavesh Professor of Economics at the NYU Stern School of Business and a former Chief Economist at the Department of Justice Antitrust Division. So the remedy phase began on October 8th with the filing by the Department of Justice and the plaintiff states of a high-level framework which put on the table a range of behavioral, structural, and data sharing remedies. The remedies range from changes to the distribution contracts that are at issue and major issue in this case, to more far-reaching measures that could affect virtually all aspects of Google's business model. So let me start by asking the panel, overall, what is your overall opinion, your general opinion of the proposed remedy framework? Maybe we'll go in, sorry, but Larry, we'll go in alphabetical order. We'll start with Ginger and Randy and then Larry. Ginger, yeah.
It happens all the time, Tom. Come
Um,
to
since grade school, I'm sure.
yeah.
Thank you, Larry. Thank you, Tom. After reading the DOJ's proposed remedy framework, I have three impressions. The first is it has a very long and comprehensive wish list. And the second is, somewhat to my surprise, I don't see an explicit and detailed description of the but-for world, taking into account potential reactions from other main players that would include consumers, Apple, Microsoft, Mozilla, and Samsung, and maybe generative AI startups as well. So as a result, I feel like the proposal does not fully consider the potential costs and unintended consequences of the proposed remedy. And my third impression is a lot of the remedies proposed seems to go beyond the Google search case itself. The case focuses on Google's distribution agreements, but many remedies go into, for example, advertising, Chrome, Google Play Store, Android, and even the AI space. And those tends to touch on behaviors that either have not happened or have not been decided by the court to be anti-competitive. So sounds like DOJ tried to preempt future potential actions. That's my impression.
Well, hopefully we will get to discuss the but-for world during the course of this panel. But Randy?
So I guess what I was struck by immediately when I downloaded the document and then printed it out is the fact that the number of signature pages actually exceeds the substance of the document. So that says two things, I guess, that there are a lot of parties involved in this case and lots of lawyers. And I think maybe I'm the only lawyer on this panel. The rest of them must be in the case. And then the second thing to note is that this framework, as Tom described, it's just the starting framework. So look, honestly, when I got this document, and just so we're clear where we are, they say they're going to file a more comprehensive document by the end of November. as we head then into a, possible remedies trial, I guess, in April of 2025, I immediately reset my antitrust syllabus to push Google farther down the line so that we can actually see the November document before we do this in class. All right, that's all by way of intro, I guess. Look, I'm not surprised. I heard what Ginger said. I guess I'm not surprised that, they're doing more than the distribution agreements. We're obviously going to talk about how you might run it that directly. There's some straightforward ideas there that I suspect they're going to reject, but we'll see what to make of that. They clearly, want to look forward. And you win, and we're not going to talk about the liability phase, I take it today. I think Google will run pretty hard at the liability finding on appeal. Even as I should say, I think the opinion's a terrific opinion in so many ways. I really think the judge shows a deep knowledge. At the same time, right, as we get to the exclusivity discussion, I don't know that that works quite as well. But I'm not surprised that the government wants to go bigger. And I'll say, look, we haven't done a case like this since maybe Microsoft. And so this is going to set maybe a framework going forward. So I think they want to be expansive.
Larry?
Well, the cost of going third is many of the good things have already been said. But, and basically I agree with what Ginger and both Randy said. It felt like a kitchen sink kind of, let's just throw everything out there. And then as we think more about it, we can come back and build on the things that we are interested in. I was struck, and it's sort of related to your question, that it appeared that the Department of Justice had not thought especially hard about remedy beforehand, that they were, after they received the liability decision going in their favor, then, oh, gee, I guess we need to start thinking about remedy. Now, that may be part of the large numbers of plaintiffs that Randy mentioned, but still, I just that struck me. The last thing
wasn't that also kind of a characteristic of the Microsoft case?
I'm now I've got to think back 25 years ago, and what did I know and when did I know it? But I think, well, no, you may be right that the proposal to split Microsoft into an operating system company and an applications company may have sort of come out of the blue. It took me by surprise at the time.
Tom,
anyway.
that's my impression as well. So I agree with you and Larry on that.
All right. So last thing I want to point out is that if, as the Justice Department is going to continue to argue, the goal is to create a more competitive environment, indeed the competitive environment that would otherwise be in place today had there not been these illegal actions, then looking around for other things that the judge could ask Google to do, not just the distribution agreements, strikes me as a not outrageous thing for at least to be out on the table. Let me just add one more thing, which is there's a saying in Washington, if it ain't broke, don't fix it. And there are, a considerable number of people who, thinking about this case, say it wasn't broke. They're sorry that the Judge Mehta came out where he did, and they will want a minimalist remedy, stop paying for the distribution, and that's it. Others think, gee, there was a lot of breaking going on, and we need a very expansive remedy to deal with that breaking. So again, thinking about the remedy is conditioned on, do you think there was a problem before?
Yeah, so I wanted to, I mean, this gets maybe a little bit to what Randy was talking about, the liability phase, but I mean, how do you think the way they framed the harms, talking about pernicious harms, I mean, it gets to what you're talking about, Larry, that, I mean, a lot of people are fairly happy when they use the Google search product, and they probably think nothing's broken. So, I mean, how was anybody surprised that they came out very strong in terms of characterizing the harms? Or maybe that's just typical, they're advocates on one side.
That doesn't surprise me. But also, and again, echoing what Randy said a few minutes ago, I don't remember seeing the word pernicious in Judge Mehta's decision. It's a very, it's a very reasoned decision. He finds that there was liability, but he doesn't have, call it florid language in the opinion. At the same time, he's not reluctantly coming to where he came out. He says, look, I think the preponderance of the evidence shows there was a problem. They did cross the line, but he's not florid about it.
I'm happy to say something. Ginger, do you want to say something, or then I'll go? So look, I think go ahead. No, go ahead.
No, you go ahead. You go ahead.
Okay. So look, I think the opinion, look, people can talk about Google and, is it the product it once was? We could have that conversation. But I think the opinion reflects more, sort of a reasonably firm belief in the competitive process. And I believe in the competitive process. And so, well, to what extent has Google distorted that process? And God only knows what products we would have in a, as Ginger puts it, the but-for world. So I think that's the focus of the opinion, and that's a fair focus.
Ginger, did you?
Yeah, I want to come back to the but-for world. I was quite surprised by the opinion. I agree with Larry and Randy that opinion is quite thoughtful and reflect the judge's strong belief in market process for competition. But on the other hand, I'm sort of surprised that he seems to dismiss the need of having a very detailed description of the but-for world. And it seems like, just reading between the lines, the but-for world in the judge's mind would be a world without the Google's default distribution contract. But somehow Google may still be a better product as its innovation and other efforts deserve, and as many consumers has expressed their preference over. And maybe going forward somehow without this default contract, then the competition in the general search market, as well as the text advertising market, including the future maybe AI-powered search engines, will be sort of a level play field between Google and other existing and potential players. So that's my impression of the potential but-for world.
So I think a couple things, if I could. So I thought it's interesting and a little bit this but-for world. I mean, Microsoft, I think the judge's perspective has achieved a kind of parity, at least with regard to users on search, not necessarily advertisers, on the desktop. I'm going to be really clear about that. So there's all this discussion, Tom, as you said, about scale. Bing, through the defaults on Windows through Edge, seems to have sufficient scale to achieve parity on the desktop. Where they clearly do not have parity, and this is because Microsoft did a terrible job in mobile, is on mobile. And so, you do a terrible job, it has market consequences, and that's not surprising. And so the difference between Microsoft's position on desktop and on mobile, that's really dramatic.
Yeah, that's a great point. I feel like unlike the Microsoft case where the Netscape might be described as a nascent competitor, and here Microsoft has been competing with Google in this area for a very long time, especially.
Microsoft went into search before Google did. That's a little bit of a not right, but they certainly, with regard to MSN and the day, confronted whether to build a search engine. They said, nah, we're going to outsource that to, I think I have it right, Ink Tommy. That's a name you guys don't know. So they could have done search. They were there, and they just haven't done a good job on the whole.
Well, and they also presumably have scale, right?
Oh, and resources,
And
right?
results, I mean,
When
yeah.
I look at the companies with market caps of 3 trillion, I count 3, and one of those is Microsoft.
Right, right.
Yeah.
Right. So, but also, I mean, maybe we can get back to this a little later because it seems to me it's key to the economics behind this case, and is that the but-for world is not just that there might have been more entrants, if Google didn't have these types of contracts, but there would have been more innovation. That's supposed to be the key, right? That would have produced more innovation. And I don't know the economic. Well, I don't know. Maybe we could discuss a little bit what the economics literature has to tell us about structure of the industry and innovation, and big firms relative to small firms and all of that. I mean, is there any clear guidance there? We might have had more firms, but it's not necessarily wouldn't necessarily have had more innovation. Google might have been less innovative.
I don't think the literature provides us with very good guidance here. Important innovations can come from guys in their garage. Important innovations can come out of industrial labs, and it's very idiosyncratic. The other thing I think I just want to get out on the table, I mean, there's a lot of stuff going on in this case, but the issue of scale is not something new. For at least I can remember back in the early 1980s at the Justice Department, people coming in arguing, hey, they wouldn't use the word learning curve or experience curve, but that's what they were talking about. And they would say, and so look, we need to price aggressively. We shouldn't be accused of predatory pricing below our marginal cost, whatever, because all we're trying to do is get scale, learn, and we're just trying to get better. So this whole issue of scale related to the information that gets accumulated through experience, it's not new, and arguably the understanding there is something called a learning curve goes back to the 1920s, when people noticed that airframe manufacturers had a much higher per unit cost for the first airplane they built than for the 200th airplane they built. And so this is just not a new issue.
So let's discuss some of these proposed remedies and dig down a little bit. So the narrowest remedy, and the one that seems to be would be most targeted at what seems to be at issue with these contracts, is just to prohibit Google from paying for exclusive default placement. So there's, I mean, it seems to me there's several things, and you may think of more, that could happen in that event. I mean, Apple and the other distributors could sell default placement to Google's competitors. They could adopt Google as the default without getting paid for it, if they think that's what their users want. Or they could put up a choice screen with everyone but Google paying for a place on it. How do you think this would? Do you have any idea how this would actually play out? I would assume, and maybe you can correct me, I would assume that in this whole range of remedies, at least one of them is going to be this one.
So can I just want to, you said something there, but I had a thought this morning. And so I wanted to call it the pay for play choice screen. And what I meant by that was, so you, Tom, you seem to have a vision of a choice screen where Google didn't pay. I think the issue here is maybe we want to, and I'm put it, we want to decouple the question of payment from how the competition works. So Apple could say, look, we're going to have a choice screen. Anyone who wants to be on the choice screen, you got to bid for that. We'll randomize. If DOJ says we should randomize, great, we'll randomize. But everyone has to pay to be on the choice screen. And Google, vis-a-vis the consumers making choices, those numbers aren't visible. No one cares, right? So Apple would continue to get paid. Mozilla, whose business goes away if they can't get paid, would continue to get paid. But the choice screen then means Google's not buying the default placement, which, look, the biggest surprise to me in the case was how valuable that default placement seems to be. So I never understood why Google was paying billions of dollars to Apple. That was always a mystery. I assume we don't all choose Google. And there's an exhibit, which isn't public, where Google does an internal study. And that internal study says we would lose a whole bunch of searches on iOS if we were not the default placement. That surprised me, but that's what it seems to say.
Let me just jump in quickly, Randy. I think you talked about Apple being required to do something.
Well, I don't want to say
I'm
that.
not-
I hope
I'm
I
not
didn't
a
say
lawyer.
that.
I'm not a lawyer.
No, I agree.
So I don't believe that Apple can be required to do anything.
They are not a party here.
Right, okay, all right.
I agree. I misspoke.
So the way I understand how any requirement for a search screen would work, at least one version, is if I, either on my laptop, on my smartphone, come to a Google search page with a Google box, first, Google has to show me a choice screen that says, do I want to switch to Bing? Do I want to switch to DuckDuckGo? Do I want to switch to Picker Search?
Which is, so we're clear, just fantastic. So Picker Search.
Picker Search. Okay. It's Google that is going to be required to do something. And at least my vision is that would be on the first time you bring up the Google search box to begin with. And then how often does that choice have to be offered to the searcher? Every time?
Yeah.
Geez, that slows down search. Once a day, once a week, once a month, once a year. There's some issue of frequency, but I think that's, there's going to be that choice, but it shows up, Google having to.
Yes, the only thing I'm going to say, and then I'm going to stop, and Ginger's going to say something, I'm sure. So look, Ginger took us to the but-for world, and the but-for world is one where Apple's getting $20 billion a year right now, and presumably is not eager to walk away from that money. So how they're going to respond, and I think that's where Ginger was taking us, is a critical issue here. And so the choice screen that I was talking about was one where I guess I called it the pay for play choice screen. Apple would choose to do that. You're absolutely right. Obviously, Larry, DOJ can't force Apple. All right, I'll stop there.
Yeah, and I totally agree with what Randy and Larry have said. But if no matter what's a remedy in this case, it's going to set a precedent for the future cases. And we know the default bias on consumers' mind is not just limited to search engine, will be limited to many things, especially in the mobile world. So if we're thinking, what's the guiding principle of banning somebody from signing a default contract, but allowing others to sign a default contract? I couldn't find myself to be very clear on that. Like if, say, the guiding principle is we're only going to disallow dominant firms from signing such a default contract, right? Like in the Google case here, how are we going to define dominant? Is 90% dominant? Is 51% dominant? Is 40% dominant? So that's first one question. And second question is, suppose Apple cannot receive money from Google, but can receive money from Microsoft and anybody else. And suppose Bing is willing to pay enough so that Apple wants to set Bing as a default, even after knowing that most consumers may prefer Google to be the default given their behavioral actions. Then is that really good for consumers? That's their nudge to use a product that's somewhat not the first choice. And they either have to reset the default by themselves, assuming there's some cost there, or they end up using a potentially inferior product, and hopefully that product would improve to be of the same quality as their first choice tomorrow. So I think
Yeah,
that seems a tricky question to me.
Right, I was going to go there also. I mean, is really what the effect of this type of scheme would be on consumers, because it seems to me there is an argument that Ginger just made that if, to put it slightly differently, that if you know which choice consumers generally prefer, you should set that as the default and make it easy for consumers.
So when I teach this, I start with the Apple's release of Safari in 2003 and the press release for that. And what they say is, we're doing this, we're excited about it. And oh, by the way, we're doing something really fantastic. We're going to build a search engine in. That's a fantastic search engine called Google. They thought it was the right choice. There was no money changing hands. Money shows up later. This is way pre-iPhone. They thought it was best for consumers.
By the way, if to the audience listening, I am at some stage, I think, going to get to the questions that are listed here. So please feel free to write them in.
There's no question, that given, and this is an issue that's sort of lurking in the Judge Mehta's opinion. If Google had a head start to begin with, was a superior engine to begin with, then what follows? And partly it addresses, the Ginger's point, which is, well, how dominant, how would you know what's the level of dominance? But that also brings in what at least I call the Gilbert Newberry point. Richard Gilbert, David Newberry, writing in the American Economic Review over 40 years ago, pointing out that if you have a dominant firm and call it an entrant or a smaller rival, and there is some crucial resource that's up for grabs, the dominant firm is going to find it worthwhile to outbid the entrant or the smaller rival, because the dominant firm is protecting monopoly profits. The best that any rival could hope for would be duopoly profits. That to me is a real dilemma when you've got a crucial resource. Google's dominance, the head start, would have naturally led it to be bidding more. It would be harder Bing as a smaller rival to match Google, because all they could hope for would be duopoly profits.
That's great. I think of that point on the monopoly duopoly point as just like breathing the air. We all know that, but where the origin was, I guess I didn't know. So I'm happy to hear that right now. That's great.
All right, it's American Economic Review, 1982.
I wrote it down.
Gilbert Newberry.
Got it.
And I want to add a few points related to this default. Mozilla received, I think, $480 million from Google in 2022, which accounts for 81% of their revenue. So if Google is not allowed to pay that much, would that hurt the innovation operation of Firefox and other products from Mozilla, right? That's number one question. And number two, similarly for Apple, Apple received $20+ billion and Samsung received some dollars. If they're not allowed to receive this amount, or they end up receiving smaller amount from somebody else, does that mean other services, including the phone itself, will be more expensive? I mean, these are the potential ripple effect of this similarly simple ban on the default contract by Google.
Before we go on to some of the other potential remedies, let me see if I can get you guys to guess or give educated guesses to the question of if this is part of the remedy, which I think probably it will, we probably agree it will be, prohibiting Google from paying for, will that one, produce consumer benefits, two, result in more innovation? I mean, it seems to me it seems to me the theory that has to be behind what the judge is doing DOJ is that we'll make life a little less pleasant for consumers in the short run, in the hopes that that over time we will get more entry, more innovation, more competition, more innovation. But that's kind of, I know speculative is a legal term, and I've never, but still.
I think that's right. That the thumb on the scale, whatever metaphor you want, restricting what Google can do in order to somehow recreate a but-for world, whatever that is, where there's more competition, and then once we're there, take the thumb off the scale and let her rip. But it's easy to say those words in great generality, and what does that actually mean in specifics? I guess that's why federal district court judges get paid such handsome salaries.
Right. Well,
Yeah,
let's
look, go ahead.
No.
All I was going to say, look, it seems to me the vision has to be that getting more scale to Microsoft on mobile would increase competition and increase innovation. That's the story. I'm completely with Larry. We can say those words. What the reality is, I have no idea. But that's the nature of competition, right? We're not supposed to know the end point. We're supposed to believe in the process.
Right.
And Tom, to answer your question, I think that depends whether the ban on the default contract is the only remedy or not, right? If this is the only remedy, I would say it's probably hard to predict how the innovation would change, because who knows how Google will use with the extra money and how Apple and Mozilla and Microsoft will react with this change. But if there are other remedies, I mean, DOJ has a very long list of other remedies. I think many of those probably will affect the innovation incentive of every player here as well.
So do you think, when I was in government, we always knew that the way to write a memo was to put all the options, put A, B, and C, and you really want B, so you make A and C look extreme, so in one way or the other. I do assume that DOJ is going to propose a whole range of options, probably more than three, but and maybe the judge will pick something in the middle. But obviously, there's been a lot of talk about a structural. Let's talk about the structural issue, because I certainly don't want to run out of time before we do that.
All right, let me leap in on structural, and please understand, this is not what I would do if I were the decision maker, but the idea of requiring divestiture of Android, requiring divestiture of the Chrome browser is not an outrageous idea. It somewhat parallels what Justice had and Judge Jackson had approved in Microsoft in 1998-99. And the basic idea would be an independent Android is more inclined to make, call it, on the merits decisions about what search engine to have as default, might even create its own search engine, creating more competition. Similarly for Chrome. And so that's not an outrageous idea. I don't endorse it, because I think even after decades of studying it, we don't understand enough about the economies, efficiencies of these kinds of vertical and co-op and complementary arrangements. And so that's not what I would do. But the idea, you get a structural separation, you don't have to worry about behavioral thises and that's. Judge Mehta is less in a position of being a day-to-day regulator, there is something to be said for that. It's not an outrageous idea.
I doubt if they did that. I don't know if they would. I'm sure they would join. They would also have behavioral.
No, hey, you can't bid for contracts is a behavioral remedy.
Right, and even if they had the structural, they would probably have that as well.
Yeah, no, but again, I just wanted to get that. It's not, it's not Looney Tunes. It's really not.
So Larry, in that world, do you think we would like auction off Android or auction off Chrome? And what does that look like? And who buys? And is that, I'm not sure when you say split it off, I'm just trying to.
I'm a guy who lived, I wasn't part of the decision of the AT&T breakup, but I lived through a lot of the thinking about it. And I just see it as you've got to draw lines somewhere of what's Android, what's Chrome, what's Google search, and you sort of separate the IP, you separate to the extent you can the people, and you have a shareholder distribution so that you've created three freestanding companies with separate managements and separate IP and at least initially separate human capital. That's the way I would envision something like that. In AT&T, it was primarily physical capital, but there was some human capital there. Here, a lot more IP and human capital, but just three spun off.
Look, there was a central vision, though. I mean, AT&T is obviously our last major breakup. Obviously, we looked at Microsoft briefly and then backed away. The AT&T breakup, I think, was driven by two things. It was driven by AT&T proper's desire to be free of the 1956 final judgment, because that was keeping them out of the computer business, and they wanted to go into that business at a time when communications and computers was converging. And then a conceptual, and I think this was Baxter, a conceptual clarity that, look, the regional Bell operating companies were still going to be treated as regulated natural monopolies, and the new AT&T was going to be competitive in a market. I use this phrase in class and I get blank stares. Long distance. What is that? No one knows, right? But that was obviously the world that we lived in then. So there was a conceptual clarity to what was going on there. I'm not sure that maps here particularly well.
Yeah, I sort of agree. I feel like the structural remedy as a prescription is not exactly targeting the disease. I mean, if you look at distribution contract here, the most expensive contract is between Google and Apple. And given that Apple is not the party, in the case, the court cannot do anything ordering Apple to do or not to do something, right? So it's sort of like looking for maybe the second best of Android, because Android is owned by Google. But I just don't see a very clear connection of like how ownership of Android or Chrome or Google Play Store has a direct causal impact on how like decouple them is going to improve the consumer welfare or advertiser welfare.
Well, I think maybe what the people who are proponents of that would say is that if you had an independent Android that Google couldn't buy default placement there, they might be inclined to sell it to somebody else and kind of jump. I think the idea is to jumpstart competition. That's not my view of the way of what should be done, but I think that's what the proponents of that would say.
But you could do that by intervening directly on forcing them to like auction off Chrome, distribution, or the same for Android. Look, Google, I heard the phrase Google owns Android. I don't know what to make of that. It's like open source software, but their business model finances all the development there, and that's true on Chrome. And what that would look like in the world in which we split those off in the way that Larry was describing, I don't really know at all. That's easy.
And if the goal is to promote competition and then clean start, like you could have the choice screen as Larry described, right, on Chrome or on Android without the structural remedy of breaking up.
Yes, I agree with that completely.
Well, let me see what the, well-
There one remedy we haven't talked about, which has been put out there, is requiring Google to share at least its current block of information. However many petabytes of information is out there. Just make it available. That's sort of a structural thing, especially if you say it's a one-time divestiture. It's not a continuing thing. They don't have to continue to share what they learn in the future, but hey, we're trying to make up for the absence of information scale in that but for world. Okay, get that information out there.
well, I'd like to ask you all, what, it's maybe a question I should have put on the table at the outset about what the goal of the remedy should be. On the one hand, you could say the goal should just be to remove what you think the anti-competitive behavior is, which is the distribution contracts. On the other hand, you could say, well, the goal is to jumpstart competition and to have a remedy that somehow offsets the past 10 years of purportedly anti-competitive behavior. So, is that, when jump-starting competition, I know that we talked about that a lot in the Microsoft case and stuff like that, but it's kind of then you're really getting into to managing the company. I'm not sure they talk about a committee of experts to monitor to monitor the remedies and everything. That's seems like kind of a big deal to do with a company that by and large consumers like.
Yeah, I saw the goal is to restore the competition harmed by this particular behavior, but somehow not hurting the competition in the future in this particular area, as well as adjacent and related areas. That's kind of the implicit goal in my mind.
Look, the information sharing, and that's what Larry mentioned. Look, I get it conceptually, right? Bing has been deprived inappropriately, anti-competitively of scale, especially on mobile. That's the idea. Let's give them the scale they would have had. And the way to do that is to give them all this data from Google. I get it. Man, the mechanics of that, I think, is going to be hard. And we're seeing that play out in Europe with regard to the DMA, or at least we're going to see that. So it's not as if, again, Larry's been saying what's crazy and what's not crazy. It's not crazy, right? It's hard, and maybe it would then restore the competition that we would have had in the absence. Now, I think they're going to push, Larry said, maybe a one-time data dump. No, I think they're going to want it to be ongoing until they've caught up. So that's hard, not easy.
But if we're thinking about logistics, I think the devil's in the detail, right? The data that Google has were upon the consumer's consent of giving Google those data for maybe Google's internal use. And now let's say we're going to zip that into a big file and dump on the lap of Microsoft. Would that automatically violate the consumer's consent? And if yes, how you're going to mitigate that before having that data created and available to competitors?
Oh, Ginger, that's I hadn't thought about that consumer consent aspect of it. That adds, I'm not going to say one wrinkle, tens of millions of wrinkles to that issue. Randy, you're more skeptical?
You'll set up an opt-out dark screen. The consumers will be sheep. It'll be fine.
What does it do? What does it do to incentives? Presumably, Google has spent, it's a big investment accumulating that data, and now you say, well, this happens in other public utility type of cases. It's obviously, well, it's a disincentive to invest if you got to share it with everybody else, and it's also a disincentive for the entrants to invest. They, assuming they can get it, get it for free. I don't know exactly how this would work in practice. It might not really be getting that much for free, but
Well, but that's why Randy may be right that there may be this initial idea of ongoing sharing of information,
no, I think
which is
people are
why the
talking
idea of just all right, here we are on October 22, 2024. Here's the amount of information that Google has learned over the period where they were making these illegal distribution payments. That's the information. Again, we need to get past the consumer permission issue that Ginger raised, but here's the information there. Now you're caught up. Good luck, and let's move forward.
So a major question that we haven't talked about, and maybe this will be the last topic, is AI. That's clearly, I think, a big part of this whole issue. I guess the question really is, I mean, is AI a pro-competitive development, and at least in this world? I might have thought so, but the discussion in the remedies document and elsewhere is that we somehow need to constrain these companies from. I mean, I guess the idea is that the incumbents who already have a dominant position in other things, we don't want them to have a dominant position also in AI, which they already have. But so I mean, maybe I'll start with Ginger. How does AI play in this, and how should it play in this?
Yeah, very good question. I think AI is potentially a very large competitor, or I should say a series of competitors in the general search area. And I think Google will be a very important competitor there along with other people. So whatever remedy DOJ or the court ends up having, I feel like we want to make sure that race is a level play field. I'm sort of concerned that some remedies on the table may end up hurting Google's ability to compete effectively in that area. I understand that Google is dominant in the current technology of general search, but if we take away Google as an effective competitor from the future AI race, I'm not sure that's going to help with the competition in that area. And if Google is able to, say, gain a merit in that competition as well, we should not be against for Google to become the popular choice by consumers. But at least we should let Google and other players, OpenAI and many other startups to compete in this area. I really don't want to handicap Google just because its past action have somewhat hampered the competition in the traditional search area.
Well, I mean, I think kind of one of the narratives around the Microsoft case was that Microsoft it wasn't so much a particular remedy, it was just that Microsoft was so preoccupied with their antitrust issues that allowed Google to emerge and be as successful. Now,
so I think I think they just didn't get searched, and I think that's why they're in the mess they're in, Microsoft. On the AI, I will say I agree with Ginger that, wow, if we sort of say Google, you got to exit AI, can't do that. We're taking, a firm that we want to be a powerful competitor. Okay, I thought actually what DOJ said in the remedies, and we'll see what the November version looks like, was a little more narrowly tailored in the sense that they're concerned that Google will use its monopoly position somehow to do better on training data. And that was a little more narrowly focused, and I guess I need to see more. So that didn't scare me in quite the way something much more encompassing would scare me that I hear occasionally discussed. Block Google from AI completely, which I think would be a bad outcome.
I'm with you all the way. You know, we don't, again, one would like to try to recreate the but for more competitive world, but geez, limiting quality improvements on the part of Google just shouldn't be. And it's hard for me to envision Judge Mehta, given the sort of high level of, I'll call it reasonableness he shows in his writing of the opinion. Hard for me to believe he would embrace some, that kind of handicapping of what he clearly recognizes to be a very talented and productive company.
Mm-hmm. And even on the narrow proposal that Randy mentioned, I'll read the exact word here. By requiring Google to allow website crawl for Google search to opt out of training or appearing in any Google-owned artificial intelligence product or features on Google search, such as retrieval, augmented generation source summaries. So that's the proposed narrow remedy from DOJ. My first reaction reading this is, wow, if some artists don't want their materials to be crawled by Google, shouldn't that option be available for that artist not to be crawled by any other things, OpenAI or Microsoft or other potential competitors, right? I feel like if this remedy is only for Google, that seems to generate kind of a special treatment here.
Well, I think there was a lawsuit brought against Perplexity yesterday on these issues. So it's, this is all going to play out. I teach copyright too. It's all going to play out in that system as well.
Yeah.
Yeah.
Okay. I do have a final question. Predict. I know you guys all like to predict, so 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 what do you think? What do you think the DOJ will propose in its November filing, and what do you think the final resolution will be in terms of a remedy?
I'm not sure. It feels like DOJ is going to continue to shoot for the moon, the broad kitchen sink. So I'm not prepared to really refine my thoughts to a specific DOJ request or proposal. But I'll go out on a limb, and this may be my own wishful thinking of what I would do if I were Judge Mehta. I will predict three things. One, gotta stop the paying for distribution. Two, Google has to have a search, a screen, a choice screen when you first bring up the Google search screen itself. And I don't know, he'll pick some frequency. Maybe it'll be once a month. He'll be sensitive to this. We don't want consumers wasting a lot of time having to make that choice every minute, every hour, whatever. And then last, there will be this one-time distribution of the existing Google search database, of making it available. There'll be the consumer opt-out issue that Ginger and Randy highlighted. But those are the three things that I'm going to predict for Judge Mehta.
Anybody else want to go there?
Yeah, I largely agree with Larry. I think the DOJ's proposal actually has an item on consumer education, like requiring Google engage in some consumer education about potential search options. Maybe that will be coupled with the choice screen, as Larry mentioned.
Yeah, I guess I think the question is because Larry sort of, I don't want to say did a sleight of hand there. He went from DOJ to Meta, and I think those are different. I think those are different people, right? So I think Judge Mehta, and I thought Larry said earlier, that he seems like a smart, reasonable guy. I don't know him at all. but just the opinion. So I think something along the lines of what Larry's talking about might sell at that level, and they could get that through. If they want the precedent, they're going to go bigger. And I think the question is do they want the precedent, or do they want the chance for more immediate, rapid progress in this market? And if they want to do that, then they want to head down Larry's path, I think.
Do you think, I mean, I think that maybe for a variety of reasons, I think there's a decent chance they would propose some sort of structural remedy, which I think I agree the judges may not be inclined to give them, but is there a risk to that? Is it costless for them to propose it and not get it, or?
I just think of this as about time, right? These markets are changing so rapidly. So I think if you just care about the market in your DOJ, you want a rapid solution. So that's what I see as the cost.
And I think the two sides probably going to spend a very long time debating on the structural remedy if that's the serious consideration on the table. And on that, we probably need to couple this case with the Google ad tech case and see how that would turn out in the court and what remedies are on the table for that if the court ends up deciding against Google.
Gee,
Well-
Tom, we can have another one of these, sessions. I'm having such a good time. Let's, as Ernie Banks used to say for the Chicago Cubs, let's play two.
Yeah.
Well, we could even have another one on this after November 20th or whenever they put their actual proposal in. Well, I thought this was a great discussion. I want to thank you all for participating, and thank the audience for listening in. Thank you.
Thank you, Tom.
Thanks, Tom.
And thank you to TPI.
Yep, absolutely.
Yep. Thank you, Tom.